So, of course, the Trump administration has been doing many things, one of which, of course, was stopping USAID and funding there too. And these orders, of course, are under review by various courts in various jurisdictions as to their various legalities. Of course, at this stage of proceedings, we are not reviewing the merits. We are reviewing them on an injunctive posture, which is a different posture than the merits. We'll discuss that in a little bit more in detail in just a second. But we're going to discuss a little bit about what the U.S. Supreme Court exactly did today and what it means. So we turn to this opinion relating to on an application to vacate an order issued by the U.S. District Court for the District of Columbia. So this is in relation to a temporary restraining order that was issued by the District of Columbia, which is not a decision on the merits. It is a preliminary stage, a very preliminary stage, the most preliminary stage. And that matters for any number of reasons, right? So this is not necessarily to decide whether or not the program is legal or illegal as such. It is trying to decide what to do in the meantime while we try to figure out whether it's legal or illegal, what the Trump administration has done. So neither the District Court nor the U.S. Supreme Court at this point has ruled that what Trump has done is illegal, but they put in place an order to try to deal with it while they're trying to figure it out. And so that's what they're doing, and that's the posture of the thing. So by its necessity, there's been no trial yet, there's been no fact-finding yet, there's been no decision on the merits. This is just relating to the posture as things exist while we're trying to work out the details. Okay, so let's discuss a little bit about what happened in this case. On February the 13th, the United States District Court for the District of Columbia issued a temporary restraining order, a TRO, which is the first thing that you can get, right? It's like the very first thing in a proceeding that you can potentially get is a TRO. Enjoining, that is stopping, the government from enforcing directives, pausing disbursements of foreign development assistance funds. So it's like you can't pause those funds. And it's like you can't do that. All right, fine. The present application does not challenge the government's obligation to follow that particular order. So the U.S. government is not here on the overall TRO. They're not here trying to say that issue. They're here on a more specific issue. Okay. On February 25th, the district court ordered the government to issue payments for a portion of the paused disbursements, those owed for work already completed before the issuance of the district court's temporary restraining order by 11:59 p.m. on February 26. So these particular funds, according to the posture of the case, are for work that have been completed. So this is not just aid for the sake of aid. We are trying to pay people for work they've done. That's at least the posture of the case. All right, cool. Several hours before the deadline, the government filed its application to vacate the district court's February 25th order and requested an immediate administrative stay. The Chief Justice entered the stay shortly before 11:59 deadline and subsequently referred the application to the court. So this whole thing has been incredibly accelerated, which, fair enough. And the application is now denied by the full court. Given that the deadline in the challenged order has now passed, and in light of the ongoing preliminary injunctive proceedings, the district court should clarify what obligations government must fulfill to ensure compliance with the TRO with due regard for feasibility for any compliance timelines. The order is therefore vacated. So basically okay, well, the deadline the district court initially gave has passed, so it's no longer possible to comply. But of course, they didn't comply because it was being reviewed. And so we said that, we're not going to basically hear this right now. We're not going to hear this right now. We're going to allow this thing to proceed. So the Supreme Court is just basically saying, we're going to defer until a later time, right? They're not really, at least in their own terms, making any decision so much as making a decision not to decide. They're making a decision that we're not going to intervene and we're going to allow this TRO to go forward while the case is proceeding. So they don't want to step in at a preliminary stage. They could, but they're not going to. All right. And because the deadline has passed, obviously it's no longer able to comply. So basically, district court, you need to modify your order to give them time to comply because they can't comply in the past. They didn't comply, not because they didn't want to. They didn't comply because, we were reviewing it. And now that that's, over, you can modify. So just modify your decision accordingly. All right, so that makes sense. All right, so that is the entirety of the majority decision. It's one paragraph. It's one paragraph, and it doesn't give you a lot of information about what's exactly happening. It's just like, okay, the district court entered this temporary restraining order, trying to say how the case, what we're going to do in the meantime while the case is happening, and this is relating to payments for monies for work that has been done, and we're not going to intervene on that very narrow issue. So it's some ways a narrow decision. But of course, there is a minority, and they're not happy. And so we're going to read another decision. So the judge should put another TRO of 3 days on it. I mean, something like that. I mean, it depends on, but like basically you got to take notice, ensure compliance with due regards for feasibility of compliance. So the new order would have to, do whatever that means. So I don't know if 3 days is necessarily feasible or not. I don't know enough to know for sure. But if 3 days is feasible, then sure, the district judge could do that. That would be fine. All right. So here is what the minority had to say about the issue and what their complaint is. Does a single district court who likely lacks jurisdiction have unchecked power to compel the government of the United States to pay out and probably lose forever $2 billion taxpayer dollars? The answer to that question should be an emphatic no, but a majority of this court appears otherwise. I am stunned. And again, in some ways, that's not exactly what's happening, because the Supreme Court is simply saying we're not stepping in right now. So the Supreme Court isn't necessarily exactly saying the district court has this power. They're simply saying we're not going to tell you you don't. And the Supreme Court often doesn't decide to hear cases. A lot, right? They don't hear cases. So in some ways, that's the same thing, right? They're simply saying, so that's not quite exactly the same thing. So the majority isn't saying necessarily the district court has power. They're just saying that they're not going to say that they don't, at least at this point. And this sort of gets into a slightly broader point to some degree, because there has been this issue that's been percolating for some time relating to the authority of district courts to enter injunctions or orders that go beyond their jurisdictional boundaries. There are 94 district courts in the United States. And so, you can go to any one of these 94 that you hypothetically have that would have jurisdiction, and any one of them could issue an order with potential nationwide impact. So this has been an issue that's been simmering for some time. This is not a new issue. This has been an issue I've talked about in the past with this issue. And I don't necessarily know what the answer is here. I don't know what the answer should be, but the United States Supreme Court at some point just really needs to clarify this one way or another. They're not going to do it today. Hopefully they're going to do it at some point. Just tell us what the rules are exactly on this and sort of what can district judges do, right? District judges they've just been doing it, and they've been doing it for 50 to 60 years, depending on how you count these issues, right? And so no one has really said they can, but no one has said that they can't. And so maybe it would be time for someone to clarify that would be nice, but we're not going to do it today. Okay. Let's read some more. Can Trump just pay it out as he wants? No, the court is going to provide an order about what has to be paid and when. So the court will say, you have to pay the money by this date certain. It's not like he just can pay it whenever. The district court is supposed to set a new deadline, and Trump has to pay it by that deadline, or he'd be in violation of the court order. That's how that goes. So that's the thing. I'm sure the judge will just decide they need to know more and set it for not enough time, and not just go for preliminary injunction so it can be appealed. I don't have any reason to believe that to be true, but okay. It seems so wrong. Which part seems wrong? You're going to have to clarify that when you say it. What's it? What seems so wrong? That district judges can issue injunctions that have impact, or what exactly? I mean, I'm happy to discuss with you. I just need more to know what we're talking about. Okay, great. All right. So the court how to pass out the money. I still don't know what that means. Do you mean that you think, I don't understand what you mean. Do you mean that, I don't understand what you mean, how to pass out the money. I don't understand. Courts issue these kinds of decisions to some degree all the time. The dissent is going to talk about why they think it's problematic in this particular case, but judges issue TROs and injunctive relief to try to figure out what should we do all the time. So I don't know what you mean. Supreme Court getting more unconstitutional? I'm not 100% sure that's necessarily possible, and that's not what's happening here either. They haven't defied the Constitution. They're just simply saying we're not going to decide right now, and it's discretionary review on a TRO. So I don't know what you mean by that either. Danny says, I mean the judge set the original TRO on its own timeline, so I don't see why they wouldn't do it again. Well, they will. They will set it on their own timeline in when they figure out, what the relevant time frame is. So they absolutely will do that. That's what the Supreme Court just told them to do, basically, in so many words. So yeah, that's exactly what they're going to do. In capsule form, this is what happened. Respondents are a group of American businesses and nonprofits that receive foreign assistance funds from the State Department and USAID. They brought suit and claimed the current administration's temporary pause on foreign assistance payments is unlawful. On February the 13th of 2025, the district court entered a temporary restraining order requiring the government to halt its funding pause. It based that decision on finding that respondents are likely to succeed in showing the government violated the Administrative Procedures Act. Now, this is not an invalid thing. The Administrative Procedures Act is basically the rule to make rules, right? And it binds agencies. It doesn't bind the White House, but it does bind agencies like USAID. So the White House can say, the White House isn't bound by it, but once that gets implemented on the agency level, it is bound by it, right? It's the way that you make rules. It's the way you do process. So it provides a mechanism for how to do that. That often includes public comment and notification so the public can comment and so forth and so on. So all the rest of it. They can be unconstitutional on occasion, noted. The relevant time frame is determined by who? The district judge determines it. The potential Trump-hating judge? Yes. Or the executive branch telling them how long it will take? No. The district judge determines how long it will take, and because that's who makes decisions, and the judge will make that decision after asking the parties for comment relating to how long it would take them to comply and make a decision. That's what they do. Great, moving on. So anyways, the Administrative Procedures Act is a big deal relating to this, and it is designed to make sure that the executive branch, particularly its agencies, do things in a thorough and somewhat methodical way. The Supreme Court didn't really do anything here. In a lot of ways, that's true. After issuing the TRO, the district judge grew frustrated with the pace at which funds were being distributed. And on February 25th, he sent a second order requiring the government to pay out approximately $2 billion. Then the dissent continues. The judge brushed aside the government's argument that sovereign immunity barred this enforcement order, and he took two steps that, unless corrected, would prevent any higher court from reviewing and possibly stopping payments. First, he labeled the order as a non-appealable TRO, and second, he demanded money be paid within 36 hours, which is one hell of a short time frame, I will agree. This left the government with little time to try to obtain some review of what it regarded as lawless order. The government moved for a stay of pending appeal in the district court, but the judge shrugged off the government's sovereign immunity argument and ignored the government's representation that most of the money in question, once distributed, could not be recovered. The government filed quickly an appeal to the United States Court of Appeals for the District of Columbia, but with only 4 hours to spare before the payment deadline, the DC Circuit dismissed the government's appeal because it took the district court's TRO label at face value and determined it lacked appellate jurisdiction because they don't do appellate jurisdictions over TROs. Danny says, okay, yeah, I watched the video from Four Box Diner. I have no idea what that is. And he said that, which was where my confusion came from. LawTube all over the place on this. I have no idea who Four Box Diner is, and I'm the best place for Supreme Court coverage, bar none. And all my fellow LawTubers will tell you. No, everyone thinks I'm the best on the Supreme Court. As far as I can tell. They all think I'm the best on the Supreme Court, so I'm the place to come to avoid confusion. or get the most correct answer, one of the two. Let's see where we were. All right. So we're nowhere else to turn to and a deadline fast approaching. The government asked this court to intervene. At the last moment, the Chief Justice issued an administrative stay, which he can do, right? The Chief Justice is what's called the Circuit Justice for the DC Circuit. And so the Chief Justice can act alone as other justices can with respect to the circuits in which they're circuit justices. And so the Chief Justice can make decisions like this on his own in this context, which he did. But then, of course, he referred the issue to the Supreme Court for further decision, which, of course, is typical. Unfortunately, a majority has now undone that stay. As a result, the government must now apparently pay $2 billion post haste, not because the law requires it, but simply because a district judge has so ordered, which I find to be a bit disingenuous, to be honest, because district judges interpret the law. Right. And so they're like, well, the law doesn't require it, but the district judge ordered it. Well, the district judge's order, and he disagrees, obviously. He disagrees the law requires it. But, that's what the district judge was trying to do, at least in principle. And so, I don't like the way that's phrased. As the nation's highest court, we have a duty to ensure the power entrusted to federal judges by the Constitution is not abused. Today, that court fails to carry out that responsibility. Time does not allow a lengthy discussion of the legal issues presented, but a brief summary suffices to show the district court order should be vacated or at the very least stayed. To start, it's clear the district court's enforcement order should not be construed as an appealable preliminary injunction, or should be construed as an appealable preliminary injunction, not a mere TRO. So fair enough, right? The label is not the thing. The label is not the thing. We don't really do law by magic words. That's not really a thing. And so the district court can call it a TRO, but it doesn't necessarily mean it is a TRO, right? Because we don't allow the label to control the thing. We allow the thing to control the thing. And so one question might be, is it really a TRO? I mean, the district judge said it was, but does that mean it's true? Well, we can look to what it is, not rather what they called it, right? And so that's what he's talking about. So it's like the district judge said something, but, what is it actually in reality? What is the thing? And he says, it should be construed as a preliminary injunction, not a mere TRO. It's not a TRO. He continues. Good old gal says the district court doesn't care about the law. They just want to stick to Trump. A lot of judges feel that way. Well, when I'm doing legal analysis mode, which is what I'm doing right now, as opposed to political analysis mode, which I've done sometimes recently. So now you get to enjoy the difference between political analysis mode and legal analysis mode. So we're gonna enjoy that distinction, right? So when I do legal analysis mode, I try to evaluate things on its legal merits. And so I don't know what the district judge's motivations are. I'm just going to try to assess the law as best as I can. I don't know whether he's a Trump hater or not, or whatever. And even if he were a Trump hater, it doesn't necessarily mean his decision is legally wrong. Maybe it's legally correct. But there's only really one way to determine that, is by looking at the decision and trying to analyze it on its own terms. That's the only way to do things legally, to try to understand whether or not he's making the correct decision or not, notwithstanding how he feels about Trump. That's the important thing. So that's what we're trying to do. As a TRO, as its name suggests, is temporary, and its proper role is to be restrained, challenge conduct for a short time while the court considers whether more lasting release is warranted. That's what it's supposed to be. The order here, which commanded the payment of vast sums that in all likelihood can never be fully recovered, is in no sense temporary, nor the order merely restrain the government's challenge action in order to preserve the status quo, which is what a TRO is typically more for. Rather, it acts as a mandatory injunction requiring affirmative action by the government. Now, I will quibble a little bit here. I don't think a TRO can't require some affirmative step. I'm not sure that that's true, but it is supposed to be non-permanent in nature because it's temporary, right? It's only supposed to put things in hold. So it might. I don't think you can say a TRO can't require an affirmative step, but I do think it is correct to say that it can't require a permanent step. I think that's true. Kurt eats his few L's. Good luck finding that. I don't know what that means, that I eat my few L's. Well, when I'm wrong, I try to correct myself. That's for sure. I'm not God, never claimed to be. Sometimes I get things wrong. Sometimes courts get things wrong. So, I try to analyze things best as I can and just try to assess things best as I can. And just that's all you can really ask for anybody, is just try to do their best. That's all you can really ask for. And given its likely irreversibility, the district court enforces orders, effectively gives respondents a portion of the ultimate relief they want. For these reasons, the Court of Appeal had jurisdiction, and we have jurisdiction to review. Incidentally, by the way, the Supreme Court doesn't say that in its majority decision, doesn't say that it doesn't have jurisdiction. It simply says we're not going to step in. So, fair enough. Even if the majority is unwilling to vacate the district court's order, it should at least stay the district court's enforcement order until the government's able to petition for a writ of certiorari. Which, on a TRO, that would be weird. I'm not 100% sure that's even technically possible. That'd be really weird that we want to do a writ of cert on a TRO. That's weird, because you're not in a final stage. You're like in the first stage of a case, and you want to basically do a merits decision on it. It seems like odd, but I get all right. In considering whether to issue such a stay, we ask at the minimum whether the moving party is likely to prevail in the merits, and whether that moving party is likely to suffer irreparable harm. Fair enough. In close cases, we also take into account other equitable considerations. Here, these factors weigh in favor of the stay. Okay. Likelihood of success. The government has shown a likelihood of success on the merits of its argument that sovereign immunity deprived the district court of jurisdiction to enforce its enforcement order. Okay. Sovereign immunity is a thing. You can't sue the government unless they give you permission. You can't sue the government unless they give you permission. It's something we inherited from the king, and we never gave up, because why would we? So you can't sue the government unless they give you permission. And so the issue here is that, maybe the government has not given permission to be sued. So, yeah. What's the difference between a TRO and a preliminary injunction? Well, there are practical distinctions. A TRO usually comes extremely early in the case. A TRO tends to be issued in more extreme cases. TROs can come sometimes without even briefing by the other party if the need is urgent enough. See, for example, like a domestic violence restraining order would be an example where you might have action by the court even in the absence of one party. They are meant to deal with emergencies, I suppose, is the most practical distinction. And they also shouldn't be permanent in their nature, I suppose, is the distinctions I would say between the two. Please explain the likely to prevail as a condition of hearing the case. Isn't that like making decisions before the case is heard? No, it's a standard factor in injunctive analysis. Yeah, it's a standard factor in injunction analysis. You don't issue injunctions or a TRO unless they are sufficiently likely. It's a standard factor. So the four-factor test, let's see if I can remember them all, for an injunction is likelihood of success, irremediability of harm, burden basically to the one party, burden to the issued part against the issued party, and the public policy. Those are the four factors. So when you are issuing, you issue an injunction when there's sufficient probability of them winning but you haven't reached the ultimate merits yet. So maybe it's like 30%, but it's a standard fact. It's a standard analysis in a injunctive proceeding. So likelihood of success is a factor. Yeah. And it's preliminary in its nature. It's preliminary in its nature, which also is because you have a lower threshold. So another way of thinking about it would be by comparison to, for example, a probable cause for an arrest or to bring charges against someone, right? So probable cause is like, is that making a decision a person's guilty before they're found guilty? I mean, I would say no. It's just an assessment whether or not there's sufficient information in the case to provide reliable enough indicia to move forward, right? So like, probable cause in a criminal context might be like 20%. So is that making a decision before you make a decision? I don't know that it is. It's just trying to assess whether there's enough to, warrant going forward. So similar comparison in a TRO or an injunction. Sovereign immunity bars a suit by private parties seeking to impose liability, which must be paid from the public funds in the Treasury. But it's exactly what the district court did here. To say the restrained defendant shall pay all invoices and letters of credit drawn down requests for all contract for work completed prior to the entry of the TRO. So again, that was relating to work that has been completed, which might be interesting in terms of the posture. Like people who complete work do like to get paid. Is a temporary injunction more malleable than a TRO? What do you mean by malleable? The case should have been brought in the Court of Claims. Maybe. That's an interesting idea. Don't know the answer to that question off the top of my head. What about continuing maintenance? That is not contemplated by that is not contemplated by the order. The order says on its own term for work completed prior to the entry. That's not contemplated by the order, by its plain text. Sovereign immunity may be waived, but to sustain a claim that the government is liable for award of monetary damages, the waiver of sovereign immunity must extend unambiguously to such monetary claims. That's what law said, self-defense said it should be in the claims. Not an unreasonable opinion. Not an unreasonable opinion by law self-defense. Could be. It could be. That's a fair opinion. Attempting to satisfy the strict requirement, respondent points to APA's waiver of sovereign immunity for certain actions seeking relief other than money damages. And obviously, this seems to be like money damages because it's like work is for work paid, right? So that doesn't feel really like the APA. That feels like the little Tucker Act or something, or the Tucker Act, the more point, right? So they try to ground it in the APA, but it feels like the Tucker Act dealing with claims, which would be law self-defense's point. That language, as we've explained, distinguishes between specific relief, which is permitted under the APA, and compensatory or substitute relief, which is not. Fair. The other problem is the judge ordered payment without seeking proof or verifying the work that had been done. I can't speak to that. I don't know enough about the district court's decision to opine, and that isn't in this case, so I don't know that. But the relief here more closely resembles a compensatory money judgment rather than or for specific relief that might be available in equity. I mean, it does. I do tend to agree with that analysis because it's like I want to be paid for the work I've achieved. So I want compensation, which feels like the Tucker Act. So yeah. See, for example, a case which said an injunction to compel the payment of money past due under a contract or specific performance of past due monetary obligations is not available in equity. Right, because that's a legal issue, not an equitable issue. That makes sense. Sovereign immunity thus appears to bar the sort of compensatory relief that the district court ordered here. That makes sense. I understand that. Hoping to escape that conclusion, respondents point to Bowen versus Massachusetts. In that case, we held the APA's waiver of sovereign immunity covered a district court's judgment reversing a final order of the Secretary of Health and Human Services refusing to reimburse Massachusetts for certain Medicare expenditures. So that feels like comparable, right? In that case, Massachusetts had expended money and they wanted to be compensated, and the Supreme Court apparently held that the APA covered that. So that does feel like on point. Unlike the district court order here, that judgment did not purport to order that any payment be made by the United States. Okay. Rather, Bowen simply recognized a basic reality of APA review. After a court sets aside an agency action, a natural consequence may be the release of funds to plaintiffs down the road. I'm not sure I buy that distinction, but okay. Indeed, we have since clarified that Bowen has no bearing on the unavailability of an injunction to enforce a contractual obligation to pay past money due, the sort of relief that appears to have been ordered here. Perhaps that is true as it relates to this other case, Cudston. Perhaps that is a better statement of the law. The district court judge went to Canadian law school and was appointed in November after the election. I don't give a shit. Was the district judge confirmed by the Senate? Then I don't give a shit. The district judge is the district judge. Nothing you said matters. I don't care. Moving on. I don't care that they went to a Canadian law school. I don't care when they're appointed. All I care about is the law. I want to know whether or not they made the right decision. None of those things help inform me as to whether or not they made the right decision. That doesn't help me. The district court, however, failed to mention much less reckon with Bowen or Cudston before plowing ahead with his $2 billion order. I'm in a fine mood tonight. Okay, noted. I'm in a fine mood. If you don't like it, the door, you know where it is. Nor did the account of our previous suggestion that proper remedy for agency restraint, failure to pay out may be due to specific sums already calculated and passed due in the court of federal claims. The most that can be said is the district court's denial of the government's motion for a stay pending appeal. It cited but did not analyze a handful of cases echoing Bowen's discussion of the APA's conscribed waiver of sovereign immunity. One might expect more care from a federal court before so blithely discarded sovereign dignity. Perhaps so. Perhaps so. I mean, the sovereign immunity question is non-trivial. The majority doesn't really answer any of these points, which makes it very difficult for me to analyze who has the better argument because they didn't provide any. I still can't get past your words. A district judge can't affect the country or something like that. Okay, pet peeve of mine. Don't put things in quote marks if I didn't say it. That's a pet peeve of mine. Please don't do that. I really get annoyed by that. All right. I didn't say that they can't do it. I said that there's a question relating to whether or not they can that needs to be answered at some point because it's not 100% clear exactly what the rules are. And district judges have been doing it and they haven't been told that they can't. And it would be nice at some point if they clarify that. So I didn't say they can't do it. I said I have questions relating to it. And it'd be nice if at some point the Supreme Court clarified the rules. That's what I said. Finally, the government has a strong argument that the district court order violates the principle that a federal court may not issue an equitable remedy that's more burdensome to the defendant than necessary to redress injury. That too, fair point. In this case, the district court's enforcement order functions as a universal injunction defining these foundational limits on equitable injunction. And that's like more to the point, one of the things that concerns me is these universal global injunctions and whether or not district judges should be doing this. That's a concern of mine. It would be really nice if the Supreme Court at some point clarified the rules relating to this. because now you just go off to any one of the 94 districts and you get your favorite judge and they can issue you an order. And they're going to have jurisdiction against the United States government pretty much everywhere, so you can just pick one. And that doesn't seem like that's necessarily the most efficient system. So it'd be really nice if at some point the Supreme Court clarified the rules relating to this. The district court ordered the government to pay all invoices and letters of credit drawn down for all contracts for pre-TRO work completed. That order encompasses more than just the respondents, and the district court offered no reason why universal relief to non-parties is appropriate here. And this is not the sort of case in which only universal release is feasible. Even supposing the APA allows universal vacator of the rules in some circumstances, which is by no means clear, the district court order of the direct monetary payment bears no resemblance to that. It certainly doesn't relate to vacating a rule. That's true. Yeah, Tamer Spoon 3, exactly correct. This is more my point, right? It's weird that district judges can issue a nationwide injunction but have no nationwide authority. Yeah, that's really weird. I agree. It would be nice if at some point the Supreme Court clarified the rules relating to this. This has been an issue for a while now. This is not a new problem. I would really like it if the Supreme Court clarified it at some point. All right. And nobody suggests the government is unable to identify respondents allegedly owed funds and pay out only to them. Limiting scope of relief in that manner would be significant. Below the government represented respondents seeked roughly $250 million. Still a large figure, but a fraction of the $2 billion order. So we're ordering relief for parties that aren't even present. Which again raises some issues. If you rule in a federal issue, doesn't that cover the nation? No, not inherently. No. Not any more than a state court making a decision necessarily impacts the entire state. No. Yeah, no. The federal judges enforce federal law, but it doesn't necessarily mean it necessarily has nationwide impact. Not inherently, no. All right, harm to the parties and others. The government has shown that it's likely to suffer irreparable harm if the district court order is not stayed. The government has represented that it would probably be unable to recover much of the money after it's paid because it would be quickly spent by recipients or distributed to third parties. That seems very plausible. Respondents did not credibly dispute the representation, and the district court did not find that's incorrect. So the fact that there is permanent impact by this, the fact that there's permanent impact does make it a poor vehicle for a TRO. TROs shouldn't really have permanent impact. So the fact that this is creating permanent impact is a problem. I thought district courts are the federal courts. District courts are federal courts. That's correct. District courts are federal courts. That's true. But I understand what your confusion is. That's like saying that the court in Harris County is a court of Texas. It is. It is a court of Texas. That doesn't necessarily mean that its decisions necessarily have statewide impact. They're just interpreting state level law. That's not the same thing. We usually balance the equities and weigh the relative harms in close cases. For the reasons I've explained, this is not such a case when our analysis could end there. Nevertheless, respondents' equitable arguments are insufficient to justify denial stay. They contend the failure to pay the money in question would cause them irreparable harm because without those funds, they would not continue to operate or would have to reduce the work they do. As a result, they claim recipients of their services would suffer. These potential consequences are, of course, serious, but any harm resulting from failure to pay amounts the law requires would have been diminished, if not eliminated, if the Court of Appeal had properly decided the merits of the government's appeal, which it should not have dismissed. Well, I mean, it would be really weird to decide it on the merits on a TRO. That's weird too. Can someone tell us what the TRO restrains? The TRO restrains the government from not paying money relating to USAID, is what it restrains. This shouldn't even be in court. It's the judicial branch telling what the executive branch what to do. Well, that's every judicial decision in the history of time. Democrat and Republican alike, that's what the courts do. They tell Democrats administrations and Republican administrations what they can do because they tell them whether or not it's legal. That's what courts do. What are you talking about? Courts decide whether or not what the executive and or legislative branch did is legal. That's their job. What are you talking about? Do you think, and I would remind you, by the way, that any rule that you want to apply necessarily has to go both ways, or it's not a rule. So are you saying that courts should, for example, have no power to review Joe Biden's actions or any other future Democrat? Is that what you're saying? You're saying that a court should have no power to stop some future Democrat president in what they do because they have no power? Is that really the position you want to take? Are you sure? Are you sure that's the position you want to take? Have you thought that all the way through? I don't think you have. Can you file in the higher court? Typically, no. Some exceptions apply, but typically, no. Typically, you have to file in district court. Could the government put the money in escrow until there's a final ruling on the merits rather than this TRO? No, the government has to follow the order, whatever the TRO is. They can't do anything other than the order. If the order is they have to pay the money, they have to pay the money. Otherwise, they're in defiance of the order. If it's an explicit executive power, then the court doesn't have jurisdiction. Well, how do you know if it's an explicit executive power? And how do you know what that power is? Who interprets the law? Courts interpret the law. It's emphatically the province of the judicial department to say what the law is. What are you talking about? When does the TRO expire? I don't know the answer to that question. But any harm resulting from failure to pay the amounts the law requires would be diminished, if not eliminated, if they properly decide the merits. If decided in favor of respondents, the government would be obliged to pay all the money that's due, and response would suffer only a short delay. Well, a short delay of $2 billion can still be pretty painful, I'm not going to lie. And if the government prevailed on sovereign immunity arguments, neither respondents nor any of the recipients of their services would have suffered any unlawful consequences, which is true because it wouldn't be unlawful. They wouldn't get their money, but it wouldn't be unlawful. It doesn't sound like it's hero to me. I tend to agree with you. In some of the factors we've considered in deciding whether to issue the stay strongly in favor of relief. Today, the government makes the most unfortunate misstep that records an act of judicial hubris and imposes $2 billion penalty on the American taxpayers. The district court has made plain its frustration with the government, and respondents raised serious concerns about non-payment for completed work. But the relief ordered is, quite simply, too extreme a response. A federal court has many tools to address a party's supposed non-feasance. Self-aggrandizement of jurisdiction is not one of them. This is not a new problem. I would chart a different path the court does today, so I must respectfully dissent. Now, I will say this for the dissent. The majority does not really answer any of these questions. They don't really answer any of these questions. They just basically, fundamentally, they just simply say, we're not getting involved. That's fundamentally what they did, because the Chief Justice issued an administrative stay and then referred it to the court, and the court simply is denying it. So the Supreme Court is not taking any action, strictly speaking. Strictly speaking, the United States Supreme Court is not taking any action. And that's fine, right? They're simply not acting. So the Supreme Court isn't saying really anything about whether what the district court did is legal or not. They're simply saying we're not getting involved at this time. Which, okay. And so the lower judgment stands. But I do take note that the majority does not really contend with any of these issues from the lower court. The majority simply says we're not getting involved right now, which, discretionary review. So, that's the thing. Brian says there are no facts on the record to rule on the merits. Yeah, I mean, I would tend to agree. I would be difficult to come up with a merits decision at this time. I'm not sure how you would even do that right now. That doesn't even make sense. So no action means no justification needed? Well, they didn't provide one. So they didn't think they needed one. But I mean, the Supreme Court doesn't fundamentally need a justification not to act. No, they're a court of discretionary review. So they don't need a justification not to act. They don't act all the time in all kinds of situations. But the minority is like you really should have, because there are some issues here that feel like they're a problem. And the majority doesn't make any attempt to address those on any terms. So, yeah. So that's it. So it's hard for me to assess in some senses because there is no rebuttal to any of the dissent's arguments. So I can't really sit here and say like whether the majority has the idea better or the minority has the idea better, because the majority doesn't even attempt to respond to the minority arguments. So, I mean, I find the minority arguments persuasive as they stand. They're persuasive as they stand, but I don't know whether or not there's a better argument. And so that's it. Does the majority read the dissent? Of course they do. They talk about everything before they release anything. So the majority is well aware of the dissent and vice versa. Yeah. Nothing for the Supreme Court to rule on outside of lower court overriding the executive branch. Well, saying what the executive branch is doing is not legal, yes. But that's what courts do. They do it all the time. They do it under Biden. They do it under Clinton. They do it under Bush. They do it under Obama. They do it under Trump. They do it all the time. That's what they do. They determine whether the executive branch is what they're doing is legal. So, yeah. Tiero did not address the security bond requirement. Hard to explain why it wouldn't be equal to the disbursement requirement. Fair. Why can't I have contempt of court if I have a right to redress the grievances of my government? I don't understand your question. If money is not paid, would the majority presumably reconsider action? If the money's not paid, the executive branch would be in contempt and it would be a constitutional crisis. How does the district court enforce it? By the executive branch obeying the order. Otherwise, it's a crisis. I feel like sovereign immunity argument is dominant because the federal government has made a contract. Have one party fulfill, get stiffed, and then no recourse. Maybe, but that might be the law. So yeah, you might not be able to get redress if you get stiffed by the government. That might be the law. I wouldn't follow it. Okay, well then you've just upended our entire constitutional order. You have now upended our entire constitutional order. So you are not obeying the Constitution of the United States. The Constitution of the United States, which presumably you care about. If you care about executive power, perhaps you should care about judicial power. The judicial power says that the Supreme Court of the United States and the lower courts that Congress may establish may adjudicate all issues of law and equity. This is one of those issues. So so now you're defying Article 3. You're ignoring Article 3. So you're not obeying the Constitution. Don't fool yourself. You're not obeying the Constitution. Don't fool yourself. Since defense is jurisdictional, they can probably ignore and challenge enforcement. They did challenge enforcement. That's what they did. They challenged it. It went to the Court of Appeals. It went to the U.S. Supreme Court. They made a decision. They did challenge it. They made a decision. You have to obey the decision now. There's nowhere left to go. That's it. What happens during a crisis? What would happen if Trump ignored it legally? It would be a constitutional crisis. It's a constitutional crisis because the executive branch is now defying the judicial branch. It's a threat to the Constitution. It's now open defiance of the Constitution. It's a constitutional crisis. I thought you said they didn't really make a decision. Well, they didn't, in so much as they decided not to hear the case, which leaves the decision of the lower court standing. They went to the district court. The district court made a decision. They went to the Court of Appeals. The Court of Appeals made a decision. They went to the U.S. Supreme Court. The Supreme Court made a decision. In this case, not to hear it. They've exhausted all their appeals. They're done. They challenged the TRO, not contempt enforcement order. No, there hasn't been a contempt enforcement order yet, but that would be next. You hate that the lower courts have any sort of say? Well, then again, you're not obeying Article 3. Article 3 says the Supreme Court and such lower courts as Congress may establish may handle all matters of law and equity. That's what it says. And the Supreme Court doesn't have original jurisdiction anyway, because the Article 3 specifies that too. Can't they just change the law through Congress? Sure. Of course they can. Yeah, it's not a constitutional issue. 100%. Yeah, no problem. They can get Congress to change the law, and that would be fine. Yeah, that's fine. Yeah. So go do that. Get Congress to change the law. That'd be fine. The contempt enforcement could be ignored as an issue without jurisdiction until final judgment. I disagree completely. No, it can't. I disagree. Yeah. Amazing how people love the Constitution, want to throw it out when it's inconvenient. And also, they don't want to do it even on even terms, which even more pisses me off. Like, if you want to know what pisses me off even more somehow than people wanting to like disobey the Constitution, you want to know what pisses me off somehow even more than that? People who want to do it selectively. That pisses me off even more. Because, like, if you want to say, like, for example, like, I don't know, whatever, right? I don't care. Pick your favorite provision of the Constitution. If you want to say that some provision of the Constitution is a bad idea and should be overruled, cool. We have a mechanism for that. I'm not opposed to that. But what really pisses me off is when they want to do it on the unequal terms, right? They want to do it because they like what Trump's doing. I like what Trump's doing. I like what Trump's doing. I'm a Republican. I like Trump. I like what he's doing. I like what he's doing. When I'm wearing my political hat. But I'm not wearing my political hat right now. I'm wearing my legal hat. And I have to remember that any rule that I come up with, I have to apply both ways. So I can't think about the fact that Trump's in office. I have to think about the next 8 guys who hold the position. That's what I have to think about. Right? So I have to make sure that any decision I come up with, I'm willing to eat it both ways. That's the thing. That pisses me off more than anything else. It's like they like what Trump is doing. I like what Trump is doing. They don't like the fact that USAID is spending so much money. I don't like the fact they're spending so much money. They think it's wasteful. I think it's wasteful. Yeah. But like but then you want to bend the rules and you want to bend the Constitution and you want to ignore provisions. You want to ignore provisions because you don't like it that the rule is being applied to you. And you want to suddenly discard the rule, even though you would love the rule. Every one of you, and every one of you in chat, I know you. Every single one of you in chat would love this rule if it was Kamala Harris doing whatever the equivalent of this would be. I'm not sure what that would be in a hypothetical world, but every one of you would be begging the court to do this. If it was Kamala Harris doing some bullshit, I know you'd be begging the court to do it. Don't deny it. You're a bunch of liars. You'd be begging the court to do it. And so you can't have it both ways. You can't have it both ways. If you want the court to be able to step in when Kamala Harris is president, then they have to step in when Trump is president, because that's what we mean by rule of law. It goes both ways, you assholes. Nope, wrong. Well, you know what isn't wrong? My power to ban. Bye. Who else wants a ban today? Anybody else? Because I'm in a mood. Who else wants a ban? Fuck with me. Find out. And I'm not even saying that the district court is right. I'm not saying the district court is right at all. I'm not saying any of those things. I haven't looked into the district court decisions. I don't know. I'm not saying the district court is right. I have no clue. I don't know. But there are rules. There are rules, and we obey the rule of law, or we don't have rule of law. Do you guys like rule of law? Do you want rule of law? Then we obey the rule of law. If you want rule of law, maybe we should have rule of law. That'd be good. And my criticisms of the universal injunction were present when Biden was in office too. That's not a new position by me. I was critical. I made the same comments when Biden was in office. My concerns about these universal global injunctions were something I was concerned about when Biden was in office. And amazingly, I'm still consistent about it. Wow. I'm still consistent because I'm willing to apply it both ways. I'm concerned both ways. Even when the universal injunctions were trying to stop Biden, I was like, I don't know, seems a little sketchy to me because I'm a little concerned both ways. I'm not sure what the rule should be, but I'm like, I'm concerned. So it's like, yeah, so I apply that concern both ways. That's the deal. Judges have scales. They weigh. They don't worry about the label. They don't worry about whether it's Republican or Democrat. They just try to apply the law, man. That's what we do. And if that's what a conservative judge does, and should. It's the liberal judges who are activists who try to not do that. That's the bad judges. Remember? That's the judges you don't like, the liberal activist judges. Remember them? They're the ones that do what they want to do instead of what the law requires. You remember them? You don't like them, right? Don't you want a conservative judge? Don't you want a conservative judge who actually does what the law says rather than what they want? Or do you only want that when it goes your way? Activist judges when it's Trump, conservative judges when it's Biden. Is that what you want? That's not how that works, man. That's not how any of this works. Am I saying there's no possibility of a future decision on jurisdiction on the merits? No, didn't say anything like that. Absolutely not. Didn't say anything even remotely close to that. No, as the case proceeds, the case will proceed, and there will be further issues of further appeals, including ultimately, one would imagine, a merits decision, which might ultimately percolate its way to the Supreme Court. Didn't say anything even remotely close to that. Yeah, there's going to be many, many issues relating to Trump stuff for many time, and there's going to be many cases and many stages. Right. That's the thing. Yeah, it's insane. Some people think you can ignore the law because you disagree with the ruling. Yeah, if Trump can ignore the law because he disagrees with the ruling, what does that imply? Right? I mean, guys, it's not that hard. I know you can do it. It's not that hard. If Trump has the ability to ignore the decision because he doesn't like it, what does that imply? Doesn't it imply that Biden can, that Obama can, that whoever the next 8 Democrat presidents can? Doesn't it imply that they can too? Are you sure that's what you want? Have you thought this all the way through? Right? Right. Conservatives are conservative because they worry about the implications of things. They're concerned about, not upsetting things too fast. They want to be more certain and more steady. Conservatives don't like throwing everything into chaos. Conservatives like rules and application of rules. That's what conservatives are. Are you sure some of you guys are conservatives? I'm not 100% sure that some of you guys are conservatives. Let Trump defy it because that's convenient for my political taste. In Article 3, Section 2, Paragraph 2, if the Supreme Court has original jurisdiction over ambassadors, ministers, shouldn't the president be in the same category? Shouldn't he be? Well, for that one, you're going to have to talk to James Madison, not me. Let me know what he says. The president has the sole authority to execute the law of the land. True enough. Co-equal means the court have no power to interfere with the president's execution of law. Again, are you sure? Are you sure? Are you sure the courts have no power to interfere with the president's execution of laws? Are you sure? Do you really want that rule? Are you sure? Do you really want the court to have no power to interfere with future Democrat presidents' execution of law? Are you sure? You're not thinking this through. You're not thinking. Think before you say something fucking stupid and retarded. Think. God damn, think. Use your brain parts. Think, you idiot. Think. Crash out? Are you talking about me? All right, friends, does Riker deserve a ban? Is he talking about me crashing out? Because I'm not in the mood. Should we ban Riker? I think we should ban Riker. It was fun having Riker around, but he doesn't need to be here on the channel. On this channel, the Constitution is I am God. That's Article 1. There are no further articles. That's the rule of law here. I am God. Great. Moving on. And also, I'm very sure about that rule. Lol. I'm very sure about that rule. Lol. Yeah. What about B-Fish is awesome? Well, that's more an endowment I give him as a courtesy of Article 1, but yeah. You're the opposite of conservative? I mean, like, I just try to apply my principles consistently. I know. It's amazing. I know. Even though Trump is in office, I know. I'm actually going to try to apply my principles consistently. Wow. I know. It's amazing. It's truly amazing. Truly amazing. I know. It's unheard of, right? I guess you'll be leaving this channel. I guess you will be leaving this channel. It was nice having you around. Thanks. Bye. People don't learn. People don't learn. Oh, man. Strictly speaking, the Supreme Court hasn't given power to the lower courts. That's not correct. The Constitution gives power to the lower courts. The Constitution establishes the principle of the lower courts. It says the Supreme Court and such courts as the Congress may exist. So the Supreme Court didn't give the district courts power. If anyone did, Congress did by creating them. So that's not how that works. It's not how that works in the system. Xenometh XMD for $10 says, here's where I'm confused. If it's fraud, does that mean a court can force the executive to participate in a fraud? Yes. Yeah. In so much as any court can order you to participate in a fraud, yes. Because because the purest version of your question is if in reality it's a fraud, but the courts determine it's not, do you have to follow the order? And the answer is yes. Right? Even though it's a fraud in reality, but the courts didn't reach that conclusion, then yeah, you now have to participate, because yeah, that would be correct. Right? So just to make it simple, let's suppose that you and I have a contract, right? You and I have a contract, and you have defrauded me. The contract is a fraud. But for whatever reason, the courts don't reach that conclusion. Do I still have to pay on the contract? You bet your ass. Right? Even though it was a fraud, because for whatever reason, the court wasn't able to reach that conclusion. I'm bound by the rule of law. So are you. So if the courts come to the wrong conclusion, yes, you're bound by that wrong conclusion. You can appeal, and if you exhaust all your appeals, yes, you're still bound by that wrong conclusion. No one promised you it would be perfect. No one promised you utopia. They promised you the rule of law with human beings involved. Sometimes the courts get it wrong. Sometimes that's the answer. Suck it up, Buttercup. Welcome to the real world. Melissa Shimok gifted 1 gift membership. Thank you very much. Xenomath XMD says, I understand, I'm sad. Thanks for a clear explanation. No problem. You're welcome. Can Trump pay something like $1 a month if no schedule is agreed on? If the court doesn't specify it, sure. Yeah, sure. If the court doesn't specify it, then sure. Then Trump has to obey the order that the court gives. If the court doesn't specify it, then sure, he could do that because the court didn't specify. But the court would be really fucking stupid to do that, and they're not going to do that because the court's not that dumb. I mean, you only have to obey the order. You don't have to do more than that. Yeah, you're supposed to have a fair trial. That's all you get. Fair is not perfect. No one promised you unicorns and rainbows, people. And again, I don't know whether the district court's out of its mind or not. I haven't looked into the issue. I've taken no position on this at this time. I want to be clear on this, by the way. I know I've already said it like once or twice, but I want to be utterly clear on this so that I'm not misunderstood. I don't take any position at this time as to whether or not the U.S. District Court was correct or not in anything it said. I haven't read its decision. I have no idea. I just read the U.S. Supreme Court's decision. I know what the Supreme Court's decision is, but I don't know whether or not I fundamentally would do what the district court did or not. I have no clue. I don't know whether or not I do what the district court did or not. I have no clue. I haven't read the decision, so I don't know. But I'm not taking a position the district court was correct. I am saying that the issue has been appealed and suck it up. I'm saying that, but that's a slightly different thing. Can the Supreme Court be forced to take up a case? Yeah, as a matter of law, they can. The Supreme Court, for example, first of all, they have original jurisdiction. So those are cases that they're required to hear as long as there's, the other factors are present, like standing. Also, the Supreme Court can be required to hear a case as an appeal, which most often happens with 3-judge judicial courts. 3-judge district courts. This used to be more of a thing until I want to say it was like the mid 80s or something like that, when there was that big judicial reform. But the Supreme Court actually used to have to hear a lot of cases as a mandatory review on an appeal. That still occasionally happens. Not often, but it does occasionally happen. The most often way it happens is with redistricting issues, because redistricting issues are done by 3-judge courts, and those cases the Supreme Court has to hear because it's an appeal, not a writ of cert. So yes, the Congress can require the Supreme Court to hear cases. They have in the past. They used to require them to hear a whole lot more cases than they do now. The Supreme Court begged Congress for relief, and in the 80s they got it, and now it's much, much narrower. But yes, that's possible. You didn't know that? Well, I'm glad to teach you something. See, I'm glad to teach you something. Yeah. Sometimes the U.S. Supreme Court is the Court of Appeals. I'll give you another time where that happened, or where they thought it did. They were a little unclear on it, but the Supreme Court interpreted it that way. Was the issue of the TikTok ban, because Congress, when it created the law relating to that, created original jurisdiction in the Court of Appeals. So, like, remember when you guys said, can you file a suit in the Court of Appeals? Sometimes. Not very often, but sometimes. The TikTok ban was one such example, because Congress explicitly wrote it that way in the law. They said original jurisdiction existed in the Court of Appeals for the DC Circuit. So that case started its life at the Court of Appeals for the DC Circuit. And so then there was a question about, well, did the Supreme Court have to hear the case or not? But there was an issue relating to that, but the Supreme Court picked it up in any event. So I kind of thought they did for that reason, but that was an example in recent memory where that happened. What's the difference between an appeal and a cert? Well, the most practical difference is appeal is mandatory and cert isn't. That's the most practical difference. An appeal is required. A cert is not. Certs are discretionary. Is an appeal court required to take all appeals? Yes, with an asterisk. That doesn't necessarily require them to do necessarily anything in particular. But yes, an appeal court is required to hear the appeal. Now, that can be done, depending on the nature of the appeal, in a fairly summary way. So it doesn't necessarily require them to do anything in particular, but yes, they are required to hear the appeal. So, yeah. Could Congress enable legislation to defund USAID by law? 100%, no problem. Yeah, Congress controls the purse, no problem. Congress can absolutely abolish USAID by statute, no problem. 100%, no problem. Go get Congress to do that. That'd be great. Why not challenge jurisdiction? Well, they did, at least in part. We've already talked about that. Will I be doing more cooking streams soon? Possibly. I've not been eating very much, and I'm very happy about that. I think it was 357 this morning. So it's like my fourth day in a row below 360 or something. Sweet. The not eating thing is working out really well for me. Food is overrated. Would that need a simple majority in terms of Congress? No, typically legislation requires supermajority because of the filibuster. And the Republicans have shown no interest in getting rid of the filibuster because the Republicans understand the rule applies both ways. So the Republicans haven't gotten rid of the filibuster because they know the rule applies both ways. And they ain't no fools. So yeah, that would require 60 votes in the Senate. Go get them. Let me know how it turns out. Although strictly speaking, well, not necessarily, because you could do it as a budget reconciliation, because you're dealing with the expenditure of money. So you might not be able to abolish USAID completely, but you could defund them with a simple majority. As part of budget reconciliation, you could do that. So yeah, you only need 51 votes in the Senate now. Go get them. Let me know how it turns out. You're 350 today, 6'8". Well, you're a lot taller than me, so you got that benefit going than me. Yeah, I don't like being heavy. I don't like being this fat. It's not fun anymore. I don't like it. I don't like it. So the Monjourno is working, though. So with the grace of God and the power of Pfizer, oh no, sorry, the power of Eli Lilly, we're making it one step at a time. All right, well, I guess I've exhausted this stream. I've answered all the questions. So, yeah. So, I mean, on the as to the Supreme Court's decision, I mean, you know, I think the dissent made some good points. I really wish that the majority had dealt with them more directly. The majority simply basically doesn't want to pick it up at this time. There are lurking issues here, for sure. And the Supreme Court's going to have to deal with them eventually. Why they don't want to deal with it today, who can say? But they don't. And the issue of the universal injunction in particular, at some point, really could use some clarification. I'm not sure what the rule should be, but it would be helpful if we clarified what the rule is so that we knew what the rule is. That would be nice. All right. I'm going to sign off. I've been on civil law today, perhaps more on civil than others, because people are dumb and not thinking in chat, and I had to admonish you for failing to think. Just think 2 steps ahead. I swear to God, sometimes I swear to God with some of you people, just think 2 steps ahead. Jeez, just swear to God. I've been on civil law. Until later, I'm out. Have a good one. Goodbye.